happy, super duper. What is it today? Tuesday or Monday? I don't know. It's daylight savings time. It changed. It threw everybody off. You know how us bosses get down. Now, I wanted to go over something really quick with you to make you understand that everything is not what you think it is. Okay? I want you to understand that you can draft negotiable instruments, especially a bond. Now, the law library is closing right now, so I got to be quick. Now, I want you to see something here. Look. This is Benedict on Admiralty. See? 3B. I want you to take a look at this and understand this. It says effects of exemption property. Effects of exemption property. See that? And I'm going to read it to you. Now, it says here, all of the debtor's property as defined in section 541 of the Bankruptcy Code as of the commencement of a case under section 301, 302, and 303. 303 is the most interesting part, okay, of the code, including property, which can be claimed exempt. You got to look up that word exempt. You have to look up the word debtor. Becomes property of the estate. And an individual debtor may exempt from property of the estate any property specified in section 522D to the second power. I haven't looked up that part, which I should. I'm actually making a mistake. Or in the non-code federal law and in the state or local applicable to the individual debtor. For property to be exempt, it must be claimed as exempt. Okay? So, having said that, I'm going to go over here and I'm going to show you something right here. Okay? Now look, this is Admiralty. Okay? This is Admiralty book. It says liability for alimony and child support. Okay? Exempt property still remains liable for the claims of a spouse, former spouse, or child of the debtor for alimony, maintenance, or support in connection with the separation of agreement, divorce decree, or other order of the court or property settlement. This exception does not extend to any other entity to whom such debt has been assigned, other than debts assigned pursuant to section 402A26 of the Social Security Act. Okay? It's a lot of research you got to do on just 2 freaking paragraphs. Okay? Now, or assigned by contract or by statute to the state or local government entity. Okay? You contracted into the system. Okay? And when that baby was born, you signed that Social Security SS5 form, and so did your girlfriend or wife. The exceptions will only apply to liability that is actually in the nature of alimony, maintenance, or support regarding of the designation. Remember, the all caps name is a designation of a legal fiction given to the liability, whether by contract, non-bankruptcy court, decree, or otherwise. The debtor's obligation to pay the ex-spouse's attorney's fees, etc., etc. Now, child support is family law, but it's in here in Admiralty. Think. Okay? Now, there's another section over here that talks about, I'm going to show you, liens which are impaired exemptions. Okay? Then it talks about the preservation of a petition and avoided lien for the debtor's benefit. Okay? Now, coming over to here. Now, they have also driving in here. What is driving while intoxicated is also in here. Why is it in here? Why is it in admiralty? Just ask yourself. Now, from this section over here that I just read, I'm going to go back to this section and I'm going to show you something. Where was I? I was over here by child support. I want you to see for alimony, liability for alimony and child support. Now it says exemption property still remains for the claims of a spouse, former child support. Here, property of the estate. Here. Now, I read this to you before. I want you to see this. All of the debtor's property as defined in section 541 of the Bankruptcy Code as of the commencement of a case under section 301, 302, or 303. Now I'm going to jump all the way to 303. Okay? Now, it says here, 303, involuntary cases. Okay? This is the part 303. Now, I'm going to jump all the way to E, okay? And it says, after notice and hearing, and for cause, the court may require the petitioners under this section to file a bond to indemnify the debtor for such amounts as the court may later allow under subsection I of this section, okay? Now, go down to I, and it says the court dismisses a petition under this section if the court dismisses a petition under this section other than on the consent of all petitioners and the debtor, and if the debtor does not waive the right to judgment under this section, the court may grant judgment against the petitioner in favor of the debtor for costs. Okay? A, costs. Look up costs, because part of the cost could be your freedom. Okay? A reasonable attorney's fees against any petitioner that filed the petition in bad faith, any damages proximately caused by such filing or punitive damages, etc., etc. You see, it's all about the bonds. Okay? It's all about the bonds. It says here, if the court dismisses a petition under this section, other than on consent of all petitioners and the debtor, and if the debtor does not waive the right to judgment under this section, the court may grant judgment against the petitioners and in favor of the debtor for A, costs, or B, a reasonable attorney's fees, or 2, against any petitioner that filed the petition in bad faith. A, any damages proximately caused by such filing, or B, punitive damages. Okay? Now, it goes on to J, saying only after notice to all the creditors and the hearing may be, this reading is small. Look how tiny it is. It says, only after notice to all creditors and hearing may the court dismiss a petition filed under this section. 1, on the motion of the petitioner. 2, on the consent of all petitioners and the debtor. Or for 3, for want of prosecution. Okay? It's all about the bonds. Okay? Read creditors and their bonds. It was amazing talking to you today. Go read the book Creditors and Their Bonds.